Ms. Humphrey?
Thank you. Good morning. May it please the Court. I'm Janet Pumphrey for the defendant, Ray Colon. This morning I'd like to start with the 33E argument, move into the ineffective assistance of counsel, then prosecutorial misconduct, and end with motion to suppress issue. Preliminarily, though, I would like to make sure that we're literally and figuratively on the same page in terms of the multiple briefs that you have before you. In March of 2004, I filed a blue brief. Attorney McMahon filed a red brief. Mr. Colon requested that I file a motion for a new trial under Rule 30. I stayed the case here, went back to the trial court, and took, he wanted me to take all of his issues to the trial court, which I did for him. Judge Ford only ruled on the two issues that required some kind of evidentiary ruling, which was the Franks issue and also the one statement from Lisa that, just one statement that was not elicited at the trial. Then I filed in June 2006 another brief, a replacement brief that replaced my original blue brief. Attorney McMahon filed a supplemental brief. Mr. Colon has filed a pro se brief. He and I each have reply briefs. So what you have before you are my replacement.
I think we can sort it out.
Okay,
Thank
excellent.
You very much.
My first brief is not to be considered, but Attorney McMahon's two briefs are to be considered.
Well,
and I would ask
under 33E, we will always consider everything.
Thank
so
you. And I would ask that you consider Mr. Colon's pro se brief as well.
We will do that.
Thank you. These are the facts of a manslaughter case. The victim was the major drug dealer in Holyoke. What I have been told, and this is way outside of the record, is that the Holyoke Police Department had a party on the night of this murder. He was the premier drug dealer in Holyoke. He was called Gigante because he was 6'3", he was 245 pounds, he was muscular build, and he had a reputation for brutal violence. He even controlled his girlfriend through fear and intimidation because she wouldn't speak to the police until she knew what he wanted her to say to them. Mr. Colon was deathly afraid of Gigante. He had endured months and months of physically, emotionally, verbal, and assault.
Didn't he take a gun and shoot him 3 times? And so when you say manslaughter, you're saying because the victim was a big man who had a reputation for being violent, that that's the justification for treating it as manslaughter instead of murder?
Well, it's more than that, Your Honor. It's Mr. Colon's fear of him. Mr. Colon would come back from New York and sneak into his girlfriend's apartment in the middle of the night just because he's so afraid of Gigante. And it's also, and more importantly, it's Gigante's continued threats, verbal threats to his brothers, verbal threats to Mr. Colon. On the day when Mr. Colon came back from the hospital after visiting his brother Elliot in the hospital, Gigante attacked him. He punched him in the face repeatedly. He continued to hit him until people had to actually pull Gigante off of him. On the 4th of July, which was just 3 days before this incident, Mr. Colon tried to avoid seeing Gigante because he was so afraid of him by, when he went to pick up Lisa Joaquin, as he drove up, Gigante was coming down the stairs, and Gigante says, he says to him, "Get out of the car so I can whip your ass just like I did to your brother. As a matter of fact, I think I'll whip both your asses." Every time he ran into him, he threatened to beat him up. And then the worst was that Lisa Joaquin testified that Gigante told her to tell Colon that he was going to shoot Elliot, the brother, and make him watch. That's the one statement that in the motion for a new trial hearing I had wanted Ms. Joaquin to testify to, that she actually did say this to Ray Colon, but Judge Ford found that it was cumulative of all the other evidence. There was so much evidence of intimidation.
But can I ask you this? All of this evidence, of course, was before the jury, I take it.
That's right.
And the jury was instructed on what? Just first and second degree murder or some form of manslaughter?
Some form of manslaughter, but not provocation.
Right. On excessive force in
That's
self-defense,
right.
that was the only theory of manslaughter?
That's right.
Okay.
The afternoon of July 7th, Colon was looking for Lisa Joaquin, and this is the day of the incident. And although he feared that he would see Gigante, he took the chance of driving up the street. This is when they had the altercation in the car. Gigante's in his car. He's chasing Mr. Colon in cars now, bumping into him, and finally eventually forces him to crash his car. And they're going faster and faster through the streets, and Mr. Colon crashes his car because he's being chased in a car. Moments after this, immediately after this, Mr. Colon desperately attempts to reach the one person that he thinks can get to Gigante, who is Barrilito, who is Gigante's supplier. Mr. Colon goes to Pedro Gonzalez's apartment to get Barrilito's telephone number. Gonzalez tells Mr. Colon that Gigante is armed. They look out the window, and in the park below this apartment, they see the fight beginning. They see the two brothers with the baseball bats, and they see Gigante with two men with him. Again, Mr. Colon confirms Gigante is armed. And Pedro Gonzalez says, yes, he is armed. Mr. Colon takes a gun at that point and goes downstairs. When he gets to the street, Gigante is accompanied by two men. One of the men has a knife. Gigante goes for his car door, where in Mr. Colon's mind he's going for a gun. Gigante says, "Motherfucker, I'm going to blow your ass away," and that's when he pulls the gun. That's when Mr. Colon pulls the gun and he shoots 3 times. He had every reasonable belief that Gigante was armed, that he was going for a gun, and that he was going to kill either himself or his brothers, like he had said over and over and over again, particularly in the hours preceding this, but also in the weeks and months preceding this.
What was there on the facts? I'm a little unclear. This is our 4th murder case today,
That's
and the
right.
facts sometimes by the 4th case. But was there a chase in which the defendant chased Gigante?
It was the other way around.
So Gigante chased the
Defendant in the car.
And the defendant never followed Gigante, didn't shoot at him or anything like that?
No.
Just they had their confrontation and
In the
he shot
park,
him?
on foot in the park. And that was about the police.
Well, how did they get to the park from the house? Maybe you'll go explain that.
Well, they were separate. The car chase ended in a police report of about a couple of minutes after 5 p.m. The shooting in the park was a police report at about 5:20, I think. So they were in two cars, and Ray Colon crashed his car, and Ray Colon's brothers entered the park by themselves. Ray went upstairs to Gonzalez's apartment, where Gonzalez told him that Gigante has a gun, and Ray obtained the gun. And there was never any question about those facts at trial.
So he had the gun, and then he left the house.
And they left, and he went back downstairs, and here comes Gigante with 2 men, one with a knife, and there's a fight is about to ensue. The entire afternoon, plus several weeks, had been leading up to this. And so when Gigante says, "Motherfucker, I'm going to blow your ass away," and he reaches for the door of his car, and Ray Colon believes that he had a gun because he was just told he had a gun. That's when he shot. These are the facts of a manslaughter case. Even Judge Ford, there was a sidebar early on in the trial, and defense counsel basically said that Mr. Colon would plead to manslaughter. The assistant district attorney said that the manslaughter is not available, and Judge Ford said, but why not? This is a terrible thing to consider, given the fact that the victim is a drug dealer who wasn't the cream of Holyoke society. And then Judge Ford says, it sounds like it could be a manslaughter case to me. Obviously, it didn't settle. Under 33E, I would ask the court to reduce the verdict to manslaughter or even second degree, because the Commonwealth failed to prove beyond a reasonable doubt the absence of excessive force in defense of others. Given the length and history of Gigante's aggressive and assaultive behavior towards Ray Colon, his reputation for violence among everyone in the community, the fact that he was the major drug dealer in Holyoke, the fact that Mr. Colon tried to settle the differences without force. I mean, he's trying to get this mediator, Barrilito, to intervene, and he couldn't reach him before the fight began. And the fact that Ray Colon just panicked for fear that his brothers were going to be shot by Gigante in the park, whom he believed to be armed. The mitigation of the first-degree murder to manslaughter or even second degree is...
Could we just go over this once more?
Mm-hmm.
So his brothers go into the park.
Mm-hmm.
He's in the house, he gets the gun. Now, he didn't have to go out of the house, did he?
He didn't have to go out of the house, but he's looking down at the scene in the park,
Yeah.
and he sees the confrontation about to start.
Well, he could have called the police, couldn't he?
He could have called, he could have called the police. I would suggest that this is not this is a level of society
The
that...
brothers have...
Not when he's making that sort of money from drugs every week. I don't think he's about to call the police.
The brothers have baseball bats,
The brothers
right?
have baseball bats.
So they're armed.
Flacco, who is Gigante's compatriot, has a knife. And Ray Colon honestly believed that Gigante had a gun. He was told he did. He says, I'm going to blow you away, and he's going for the door of the car. It's a manslaughter case. Ineffective assistance of counsel. First of all, for failure to request the provocation instruction. If any evidence, if any view of the evidence would permit a verdict of manslaughter, in this case on provocation, rather than murder, a manslaughter charge must be given. And because the jury was denied the opportunity to consider manslaughter, they convicted Colon of murder without disproving, beyond a reasonable doubt, absence of provocation, reasonable provocation.
Let me ask you, was he charged with possession of a gun at the time that he was in the apartment?
He was charged with illegal possession of a firearm.
But during the murder, not afterwards.
It would, I'm not sure that I'm not sure the indictment actually said. He was definitely charged with illegal, and convicted of illegal possession of a firearm. Voluntary manslaughter is the killing, with respect to provocation, is the killing committed in a sudden transport of passion or heat of blood upon reasonable provocation. Here there was overwhelming evidence of provocation, and defense counsel should have asked for the instruction and should have argued this alternate theory of guilt. Again, the facts of provocation. Gigante controlled the neighborhood by the presence of fear. He was aggressive, he was assaultive, and he routinely carried a gun. He had instigated a fight with Colon, punching him many, many times. This was before the incident, until people had to pull him off and break it up. 3 days before the incident, Gigante had said to Colon and to his brother Elliot, "Get out of the car so I can whip your ass like I did your brother." As a matter of fact, I whipped both your asses. Gigante told Lisa Joachim to tell Colon that he was going to shoot his brother and make Colon watch. And finally, just before the incident, Gigante's chasing him, and there's the car chase. Gigante's chasing Colon in the car, hit his car, caused him to run a red light, and caused him to crash his car. But the precipitating event, and from the car chase to the shooting, was really only a matter of moments. And the precipitating event for Colon was watching from the window as his brother Elliot and Gigante were about to begin fighting. The weeks of harassment, the couple of hours prior to the shooting, combined with the fight beginning in the park below, is just not a sufficient cooling off period of the defendant's temper. Other jurisdictions have considered what constitutes a reasonable cooling off time and have determined that it really depends upon the nature of the provocation in the particular circumstances. I made this same argument here a couple of years ago on Commonwealth versus Cohane. I think this is a much more compelling case than the Cohane case. In that case, Mr. Cohane was involved in an altercation, left the scene, and then went with two friends and a baseball bat back to the victim, the sleeping victim, and bludgeoned him to death. And this court ruled that that cooling off period, because he left the scene and came back, I would suggest that there was no cooling off period here between the time of the car chase and the time of the shooting. It was really one about 20-minute period. Second ineffective assistance argument, counsel abandoned the defense of others theory in closing. The defense counsel strongly opened by telling the jury that the defendant went down with a gun, that he shot and killed Gigante as a result of trying to defend his brothers, because he believed that Gigante was going to do bodily harm to his brothers. He told the jury that the evidence will show that Raymond Colon knew that Gigante had threatened Elliot, that he was going to hurt him. You will be convinced that Raymond Colon acted only in the defense of his brothers in taking the actions that he did. And the evidence did show that. It absolutely showed all that was promised by the defense's opening. There was the altercation in the park. It was escalating in the park as Cologne looked out of the window. In its brief, the Commonwealth sets out all the ample evidence of the deteriorating relationship between Gigante and Cologne. The previous fight, the July 4th incident when Gigante said he was going to whip their asses, July 7th when he caused Raymond to wreck his car. Gonzalez told him that Gigante was armed. Gigante's multiple threats, the fact that Gigante reached into his car as if to get a gun. But then inexplicably, in his closing argument, defense counsel didn't refer to the defense of others theory. He kind of rambled on and rambled on. He basically said that, and he ended by saying he asked the jury to find the defendant not guilty of first-degree murder, or at the very least guilty of only manslaughter. This case was never tried as seeking an acquittal. The statements, Raymond Cologne testified, it was always tried as a defense of others case. It was always tried as a manslaughter case. And that by abandoning the defense of others theory in closing, I think that defense counsel really foreclosed that opportunity to the jury. And he should have, at that point, just hammered all the evidence of defense of others, because that's how the case was tried. It's how all the evidence came in.
I haven't read the closing because I don't have the transcript yet, but we will certainly do that. But are you saying he abandoned it simply because he didn't use those words? Or,
He didn't use those words. I mean, he should have just hammered home all of that evidence.
So he didn't hammer home the evidence.
That's right. That's right. He just, it was kind of rambling, directionless. I think it sort of gave up on the defense, and that's not. I think it was just a job very poorly done. And finally, under ineffective assistance, the failure to object. He failed to object to the prosecutors arguing facts, not in evidence. And I'll move on to that argument now. In her closing, the prosecutor fabricated an alternate theory for this case that was not found anywhere in the evidence. The evidence actually was that Ray Cologne had been involved with Gigante much earlier as a low-level drug courier. He changed his life for the better. He had given up the drug business. He had moved to New York.
But that's the evidence that you would like the jury to have accepted. The jury clearly could have accepted a different version of the evidence, couldn't they?
The jury could have accepted a different version of the evidence, but there was no contrary evidence with respect to those points, really. He was working as a barber. He was living in New York. He was involved in a band. He had just recently moved back to the Holyoke area. He was living in a number of places, and he was no longer affiliated in the drug business. There was absolutely no evidence at all that he wanted back in the drug business. No evidence that he wanted the Gigante's corner. And it was improper and prejudicial for the prosecutor to argue that Mr. Cologne killed Gigante for the business corner and for Gigante's share.
When you say an alternate theory, does that mean that – I'm not sure what you mean by that. In the opening, I assume the Commonwealth set out the evidence, and in the closing, they argued the evidence. Was there a theory set out in the opening that was different than in the closing, or am I –
She didn't bring in this motive in the opening. She set out the evidence in the opening, but this motive was devised only in the closing. And as I said, the case was tried as a manslaughter case. It was tried as a defense of others case, and should have been tried as a provocation case. But to set out this very elaborate motive for first-degree murder was contrary to the evidence, and I think could not be said to be a reasonable inference from the evidence. And it was very prejudicial because it basically painted Ray Cologne as a vile and despicable drug dealer. It suggests evidence of other crimes, which of course didn't come in at all. The judgment, I think that did
the defendant testify?
He did. He testified at length.
Prior record come in?
No, my memory is that a prior record did not come in. The standard boilerplate instructions are inadequate on that point. The motion to suppress. First of all, there was no exigency here. The police could have secured the building. They should have secured the building. They did secure the building for an hour and a half, waiting, I think, for a master key to come before they went in. The master key never came, so they did kick the door down and arrest the three suspects. Mr. Colon, as argued at the motion to suppress hearing, the motion hearing judge found that there was no reasonable expectation of privacy in his girlfriend's apartment. I would suggest that that's error. He did have a reasonable expectation of privacy in his girlfriend's apartment because he was a routine guest there. He was there 2 or 3 nights a week. His children lived there. She was the mother of his children. In Minnesota versus Olson, it speaks directly to visiting our children when we are guests at other people's homes. And there was the other.
Do we have any Massachusetts cases that say that a visitor has standing to raise the expectation of privacy? A visitor?
A visitor. I believe that there is, but it's not on the tip of my tongue. I'll follow up if I can find it.
Okay.
He was arrested at the apartment where he had every right to be, where he frequented often, where he received mail, where he had keys, where he had clothes, and where his immediate family slept. I mean, he stayed here with his kids 2 or 3 nights.
So what is the point of this argument? What is the point?
The point of this argument is that his statement, as the police come in, they take the 3 suspects out, and he says, "I am the gunman. My brothers had nothing to do with this."
So if the court were to conclude that it was appropriate for the police to break down the door and find these men with the gun that had fled from the park, hot pursuit type of rationale, then your argument makes no difference, doesn't it?
I'm not understanding why it
Well,
makes no difference. Well, the statement would have been excluded. The statement would have been excluded.
The statement was made at the time of the arrest.
At the time of the arrest.
And if the arrest was legal, then...
The arrest was the arrest was the result of the illegal entry.
But that's the whole point. If the entry was legal because it was part of the pursuit of armed people who had just killed someone...
Well, if the entry was legal, I would agree with you, but there were no exigent circumstances here. The building could have been easily surrounded, and it was surrounded for an hour and a half by police officers. They could have waited for the warrant. They did get a warrant within hours after that because they went back and they found the gun.
Well, that's different, of course. Then there are no exigent circumstances.
That's right.
Because the people had been removed.
That's exactly right. That's exactly
So they did
right.
have to get a warrant, and they did that.
And they did get a warrant, and they did have a warrant for the gun.
Thank you, Ms. Pumphrey.
Thank you.
Ms. McMahon?
May it please the Court, Catherine McMahon for the Commonwealth. Justice Ireland asked a question whether Massachusetts has a case concerning a visitor having an expectation of privacy. Commonwealth versus DeRosia. It's 402 Mass 284. In that case, the defendant was visiting his mother at the time that police officers entered her home in order to arrest him. In this case, the Commonwealth submits that the circumstances are much different. If the Court would like, I will take the arguments in the order that my sister did. This case was tried by the Commonwealth on a theory of first-degree murder on grounds of deliberate premeditation and extreme atrocity or cruelty, and the judge instructed the jury on both theories. The jury came back deliberate premeditation. The defense that the defendant presented, both in his statement to the police upon his arrest and in his testimony at trial, was that he was acting to defend himself and to defend his brothers. In light of that, the trial judge instructed the jury on both self-defense as an absolute defense and self-defense with excessive force and self-defense being a ground for voluntary manslaughter. There was no request for an instruction on reasonable provocation. The case was tried as a self-defense case. The jury heard the testimony, was properly instructed by the trial judge, found that the Commonwealth disproved self-defense beyond a reasonable doubt, and credited the Commonwealth's evidence that this was a deliberately premeditated case where, yes, there was a dispute between the defendant and the victim, Angel Ortiz, but that the defendant, who armed himself after the altercation with the motor vehicle, which was some 20 minutes before, either drove down to Chestnut Street or walked down with his brothers. His brothers were armed with bats. The defendant had tried to page the supplier that he and Angel Ortiz had used for their drugs. He was unable to reach him, so he took that person's pager number and went down to the home of a companion of both him and Angel Ortiz and asked the companion to page the supplier. The companion said that the defendant asked the supplier not to intercede, not to take sides in his dispute between himself and Ortiz. The defendant testified that he actually asked Pedro Gonzalez to ask the supplier to intercede on his behalf. The defendant armed himself and said, "This has to end today." He looked outside the window and he saw that his brothers were armed with a bat, were walking towards Ortiz. Ortiz had no weapon on his person. Gonzalez had lied to the defendant and said that Ortiz did have a gun. The brothers have bats. They're moving towards Ortiz. Flacco, a companion of Ortiz, pulled out a gun. According to the defendant's...
Or a knife.
Knife?
A knife, I'm sorry. I apologize. The defendant is armed. He approaches. He tells Flacco to put the knife away. Ortiz has his hands up, according to the Commonwealth's evidence. According to the defendant's evidence, his hands are out. He doesn't have a weapon. Ortiz, after being confronted by the defendant or his brothers, threatens to blow them away. And by the defendant's testimony, he is pulling his brother Elliot away. They're walking away while Ortiz, with nothing in his hands, approaches them, saying he was going to blow him away. When Ortiz reached towards his car, according to the defendant, not according to other witnesses, the defendant thought that he was going to pull a gun, and the defendant then fired a shot 3 times, once striking the victim as he fled in the back. This arguably allowed the jury to consider the question of self-defense, or even imperfect self-defense. The jury got that instruction. The jury rejected it. This is not a case of reasonable provocation. From the car chase to the 20 minutes down where the defendant tries to page the supplier, gets his brothers, they arm themselves. The defendant has a conversation with a police officer, friend of the family, outside of his home, doesn't report anything to him. The defendant elects, according to him, to walk because he knew he had a suspended driver.
May I interrupt you? The conversation with the police officer occurs after the car?
After the car and before they take the walk or the ride back down to Chestnut Street. So there are instances where in this jurisdiction, an interval of 2 to 3 minutes where somebody departs the scene of an altercation and returns is sufficient as a cooling off period. Here, the defendant had ample time to cool off. He made calculated determinations of what he was going to do, went up to see Pedro Gonzalez, had a conversation with him, then said, "This has to end today," before he walked out the door. He may have been provoked. He was definitely angry, but this is not an immediate and intense offense. This is not reasonable provocation. The defense counsel went with the best defense that he had. And turning to the question of him abandoning that defense, he was consistent from opening through closing, playing up Ortiz's prior acts towards the defendant, asking the jury in his opening to consider whether this is a murder, telling the jury in his closing that this wasn't murder, at the most it was manslaughter, and in that closing articulating all of Ortiz's conduct towards the defendant and his brother, and then saying that the defendant shot Ortiz because he was afraid for himself and afraid for his brother. Transcript volume 5 at 65. He didn't abandon the defense. He marshaled it with the evidence that he had, that this was arguably an imperfect self-defense, enough for voluntary manslaughter, and this was consistent. There was no switching of gears. There was no abandoning of a viable defense. He did the best he could with what he had. In terms of the motion to suppress, the motion judge took it in 3 levels. First, she determined whether or not the defendants had automatic standing. Then she determined whether or not, regardless of that, there was a reasonable expectation of privacy in Marilyn Nunez's apartment. And then she took the question of probable cause to arrest the defendant as a third point. So the motion to suppress involves 3 volumes of transcript, and it's bifurcated with several witnesses retaking the stand, going to the different issues. In terms of automatic standing, the defendant was charged with unlawful possession of a firearm. The motion judge said that had to do with his possession of the firearm at the time that he shot Ortiz. The trial judge instructed the jury on possession of the firearm as actual possession. The only time the defendant was in actual possession of the firearm in terms of what the jury heard was when he shot Ortiz. So it wasn't his possession of the firearm in the apartment that was the basis of the possession charge. It was what he did with that on the street. Even if the defendant had automatic standing for the firearm was seized not when the defendant was arrested in the first entry into the apartment, but later with a search warrant when the police went again. The automatic standing, the defendant can't extend that to any evidence other than that which amounts to the possessory offense, the gun. He can't use the automatic standing to say that the police also should not have seized him. But in Massachusetts, even if the defendant did have automatic standing, which he didn't, the next question would be, as the motion just applied, whether he had a reasonable expectation of privacy in Nunez's apartment. And there was conflicting testimony on the score of whether the defendant was a regular visitor in the apartment. Looking at the conflicting evidence, as the fact finder, the motion judge found, and there's a basis in the evidence, that the defendant had moved out of that apartment into an apartment in a different section of the city before this, and that the reason he was in the apartment after the shooting was because he knew that Nunez had a bad habit of leaving her back door open. He was not there as a lawful guest. He was there because that's where he ran to, as he knew it was a place he could get into when he was fleeing from the scene. The defense argues that her findings are clearly erroneous. They're based on a determination of conflicting evidence.
Didn't he tell the police that?
He told the police that. Yes, he did, Your Honor.
And was that
That was in his statement.
was that in evidence?
Yes, it was.
Okay.
Let's assume for a moment that there was a reasonable expectation of privacy. What's the result of that? What would result from such a finding?
Then
He couldn't be seized?
Then I guess his arrest and his brother's arrest were unlawful, but then you look to what's in the search warrant in terms of going back, and apart from the arrest, there's other evidence independent of that which would give probable cause to go back in to seize the gun. The defendant's statement to the police was taken at the police station after he was Mirandized, and it's a law in the Commonwealth that an unlawful arrest alone doesn't mandate that a later statement at another place while Mirandized is suppressed if it's voluntary. The motion judge found that it was voluntary. So his admissions that were made at the police station would come into evidence. Those admissions, which are part of the affidavit in support of the search warrant, could be relied on for probable cause, where he admitted not only that he shot Ortiz, but that he and his brothers had fled to Nunez's apartment. He thought he threw the gun away, but his brothers might have picked it up, that there was probable cause that evidence of the crime, based on evidence independent of defendant's arrest in the apartment, to support the subsequent search. And even assuming that the recovery of the gun was somehow a tainted fruit of an unlawful initial entry, which it wasn't, it was harmless in this case. In this case, the defendant all along admitted he shot Ortiz. The question wasn't who did it, but why the defendant did it. So the fact of the physical fact of the firearm coming into evidence didn't damage the defense. The defense right off the bat was, I shot him. He admitted it right when the police officers took him out of the apartment. But the question here wasn't whether he did or who did it, but it was why. The shooting was a given. So any evidence recovered as a result of the initial entry would have been harmless beyond a reasonable doubt. A couple of points. My sister alleges that Ortiz was the leading or main drug dealer in the city of Holyoke. There was testimony that both he and the defendant were drug dealing together in the city of Holyoke. There was no testimony as to whether he was the major or main player in the city.
I believe your sister said that he had, the defendant had been involved in drug sales in the past, but he had turned over a new leaf. He was a barber and
Well, the new leaf was because Ortiz kicked him out of the drug business, not because he elected to get out. The defendant and Ortiz worked together. The defendant made $500 a day. He was not a low-level courier. He was right below Ortiz in the organization. I think he testified that Ortiz made $850 a day. He made $500 a day. And what the defendant's job was to give the drugs to women who lived in the buildings at this corner in the city of Holyoke, and the women were the ones who actually did the selling, and the defendant and Ortiz reaped the profits. The defendant took his weekly cut of the proceeds but went on vacation, and Ortiz was angry with him and told him that he owed Ortiz $4,000 because you have to earn it in order to get it. So the defendant was in debt to Ortiz for $4,000, and the defendant, Ortiz, cut him out of the business. And the defendant testified that he was insulted by it. And so in terms of the prosecutor's theory of the defendant having a monetary or pecuniary motive for his anger towards Ortiz, that has a legitimate basis in the testimony right out of the defendant's own mouth and reasonable inferences from it. And the defense counsel, in his closing, had argued, it's not about the money. It's not about the money. It's about an insult that the defendant's brother had given to Ortiz that Ortiz couldn't live with. But the fact that this money was here was something that defense counsel noted because he tried to push the jury away from that rather than just to Ortiz's aggressive behavior. But the defendant had been, he testified that it was like wine, women, and song. He had a very easy life while working with Ortiz. Ortiz kicked him out of a $500 a day business. The defendant was struggling. I think he moved to New York at one point to try to make it as a barber and then came back. And Ortiz was still after him about the debt. The allegation that the prosecution was resorting to prior bad acts or trying to prejudice the jury with drug dealing is ridiculous in this case because the drug dealing that the defendant and Ortiz did together and the defendant being kicked out of the drug deal and the defendant owing Ortiz money was central to both sides' cases. This wasn't something where we were bringing in extraneous information. It was right on the record. It was right out of the defendant's mouth. And it was a reasonable inference that the defendant was angry with Ortiz, not just because Ortiz was angry with him, but because Ortiz had cut the defendant out of a very lucrative, although illegal, lifestyle. And the trial judge here told the jury that they couldn't use the allegations of the defendant's drug dealing, something which the defendant freely admitted to when he testified, as a substitute for finding the defendant's guilt, but could only be used to demonstrate the relationship between the defendant and Ortiz. He specifically limited the jury's consideration of that evidence. It could not have spilled over into an improper use or bias by the jury that was directed. It wasn't objected to by defense counsel. There's no substantial likelihood of a miscarriage of justice. The defendant's argument seems to be a struggle with the credibility call that the jury made. This court, under 33E, does not sit as a second jury. This verdict is amply supported by the evidence. The jury heard the defendant's claim of self-defense or defense of his brothers. The jury rejected it. The jury was properly instructed. Any error doesn't amount to a substantial likelihood of a miscarriage of justice. So the verdict of first-degree murder should be affirmed.
Thank you, Ms. McMahon.